versus the Department of Correction.
Thank you.
Mr. McGilligan?
Thank you. Madam Chief Justice, Justices, may it please the Court, my name is Neil McGarrigan. I'm here on behalf of Nathaniel Ahmad, who is a former inmate of the Department of Corrections, a Muslim man who had got free exercise claims under the Declaration of Rights and the Federal Constitution, as well as claims under the Federal Religious Land Use and Institutionalized Persons Act. Mr. Ahmad's claims were dismissed on summary judgment, and we've appealed the dismissal of his claims.
Let me understand sort of what remains here, if I might. The original action, or the amended complaint, alleged violations of the free exercise clauses, of course, but sought declaratory relief, injunctive relief, and damages. Is that correct?
That's correct.
Declaratory relief and injunctive relief are no longer before us. Is that correct?
That's right.
So the only thing before us is damages.
That's correct.
And also the retaliation claim, which was dismissed by the court below, has not been appealed. Is that correct?
That's right, Your Honor.
All right. So as I understand it, and please correct me if I'm wrong, the only damage actions, really, are under the Section 1983, the Mass Civil Rights Act, and RLUIPA, or whatever it's called.
It's a mouthful.
It's a mouthful. Those are the three damage claims. Or is there some separate damage claim for just a pure constitutional violation?
Those are the damage claims, Your Honor, although there also is there are claims under the Equal Protection Clause as well. But
how does one get damage? How does one get damages for a violation of the Equal Protection Clause unless it's under 1983 or?
Sorry, Your Honor, that's right. Thank you. Under Section 1983, we have equal protection claims in addition to the free exercise claims.
So those are the three sort of damage claims that are pending. They are all based on an alleged or premised on a violation of the free exercise clauses.
That's right, and the Equal Protection Clause.
Okay, correct. All right. Great, thank you.
Okay.
Can you help me with a factual question? I'm not clear, probably I missed something in the brief, but I'm not clear what exact meals he got or didn't get a DOC provided, whether he, between 1995 and 2000, whether he got some meals that were proper meals for his religion or not.
Thank you, Your Honor, and it's an important point because the Department's position is that they offered this choice between vegetarian and pork-free, they call the regular diet. But the choice didn't exist until late 2000. So that time period Your Honor has referred to from 1995 until the end of 2000, Mr. Ahmad received the same meal that every inmate in the Department of Corrections received, other than Jewish inmates who got kosher meals. Mr. Ahmad received the so-called pork-free diet, which was, by its nature, repugnant to his religious beliefs. There was nothing about it that comported with his religious beliefs. And that was a period of 5 years.
And when was he released?
I believe, Your Honor, it was in the beginning of 2002. So there was a 2-year time period, or probably a 13 or 14-month time period during which he was given this choice that the Department says makes their actions constitutionally sound. And there was a 5+ year period prior to that time when he was not given given access to a diet that does comport with his religion.
And does he agree that from 2000 to 2002 the diet was sufficient for his religious purposes?
No, Your Honor, and there are two reasons. In discovery, there were factual disputes uncovered about whether or not the vegetarian diet actually is a vegetarian diet. 2 points came up in the deposition of the Department's Director of Food Services, Mr. Zaffer, who conceded that there is on the diet, we got all of the ingredients to all of the meals. Gelatin is listed as one of the ingredients, and there is a dispute, and he didn't know the answer, whether or not that was meat gelatin or some other kind of gelatin that might be vegetarian, but he conceded that it could be a meat type of gelatin, which of course would not be halal. The other thing that the Department's meal doesn't do is provide all of the daily recommended allowance of vitamins and minerals, and the one that we discussed in Mr. Zaffer's deposition was vitamin K, Evidently, 60% of the RDA is provided in food in the department's menu, but the other 40% is to be obtained from sunlight, exposure to sunlight.
So there's a claim that it was, so there's a factual dispute as to whether or not, even if it met halal, it was nutritionally adequate?
That's correct, Your Honor.
And that is before 2000 and post-2000?
The post-2000...
No, only post-2000.
Yes, I take it right. It's 2000, right?
From December 2000 on is when this vegetarian diet was available. And there are disputes during that time period whether or not it was in fact actually vegetarian and nutritious. But that long time period before 2000, of course, there was no access to any diet that is constitutionally sound. And the cases are extremely clear. There is, I don't think, any dispute that an inmate is entitled to a diet that comports with the inmate's religious convictions. I don't think the defendants have disputed it. It's clear under the federal Constitution. There's a Massachusetts regulation that says the exact same thing. If an inmate has special dietary needs imposed by a religion, that inmate shall be given access to a religious diet.
There's no claim here that this was not a sincerely held religious belief, correct?
The sincerity of Mr. Ahmad's beliefs is conceded by the department with respect not only to the diet but to prayer oil and the need for a proper prayer rug and the religious medallion. These are all conceded to be sincere religious beliefs of Mr. Ahmad's. The questions, I think, the case is full of issues, but I think that there are probably a couple that deserve particular highlight today. And one of them, of course, is what the standard is that ought to apply under the Declaration of Rights to an inmate's free exercise claims. There is sound case law in the Commonwealth of this court, the Desolates case, that says in all cases in which a law or a regulation burdens religion, that there is a strict scrutiny, compelling state interest, narrow tailoring test that applies. Desolates was not decided in...
I take it, assuming that I did not agree with you, and you were under the federal, what's it, Tanner? Or
Turner versus
Turner, safely, yeah.
There would probably be serious questions with respect to food. There would probably be serious questions with respect to a prayer rug. There would probably be serious questions under Turner with respect to the oil. And the question is whether there would be serious questions under Turner with respect to the medallions.
The medallion is a little different than the others, I concede. There is less evidence in the record from the department itself that undermines the validity of their concerns. And Your Honor has noted that I think with prayer oil and the prayer rug and the diet, there are lots of factual disputes. The record is a little less clear on the medallion point, but the medallion point is still an important one. As we've noted, there's no question that it is a sincerely held religious belief of Mr. Ahmad. The department has offered up, in the same vein as the other religious items, generalized concerns about what might happen if an inmate has the wrong size medallion or the wrong size chain. But there is nothing in the record to substantiate any of those concerns. And in fact, the one comment that I can recall is a somewhat dismissive comment from the department's imam and Islamic expert, something to the effect that Islamic medallions aren't so important, they are just a black Muslim thing. An American black Muslim thing was his
But the real issue here is that are you complaining about the fact that only certain types of medallions were permitted, certain sizes, et cetera, or were you complaining about for a 13-month period the provider of these things was no longer providing them and the department was searching for a new provider?
Well, that's right, Your Honor. There was no provider for a long period of time, and it was at least some 13 months, but I think that's about right. And Mr. Ahmad had proffered a number of examples of, I think, sources where those could have been obtained, not to the satisfaction of the Department of Corrections.
Well, you have to admit the department has a very strong interest in ensuring that any company that is going to be making its products available to inmates is going to do so in a proper fashion. There's all kinds of contraband that can come in through objects. There's all kinds of misuses that can be made of objects. There's a million reasons why the department would want to have an approved provider for that.
Yes, although one of the providers suggested by Mr. Ahmad was one that was already approved by the department to supply, I believe it was watches. I forget exactly what the article was, but it was already approved and approved.
So what did the department say about that?
I can't recall specifically, Your Honor, but it was a rejection of Mr. Ahmad's suggestion.
And did your client exercise all of his administrative remedies with respect to that rejection?
I think that Mr. Ahmad, I don't know that there's anything in the record showing he filled out I think there's a religious services request form or a complaint. The trouble with the exhaustion aspect of the defendant's case is that it's an affirmative defense. The defendants didn't have any evidence of whether or not Mr. Ahmad had made these followed these supposed administrative remedies until their summary judgment papers, at which time they submitted affidavits from two people they'd not disclosed during discovery, and gave the testimony that way. There was an unresolved motion at the time of summary judgment to strike those two affidavits, which would have precluded which would have stricken all of the evidence in the record.
So there was evidence, at least at the summary judgment stage. You're challenging it, saying it was late, shouldn't have been permitted, that in fact he never filled out any of the forms that would process an administrative complaint to the Religious Services Committee.
That's a fair point, yes. There was evidence. We moved to have it stricken, and the motion was not ruled on, although I take it from the disposition of the summary judgment motion what Judge Kern's view of the motion was. But there was not a specific ruling on it. But getting back to the standard...
And I take it the exhaustion problem, assuming we conclude that it is a problem, applies not only to RLUIPA but also 1983?
It would apply to those federal claims, that's right.
Okay.
It would not apply to the state law claims. And that's one of the reasons it's important, I think, on this record to decide what the standard is that ought to apply under the federal, under the Declaration of Rights. And
are you suggesting, I think you are, that she in effect denied that motion to strike without saying so?
It's speculation on my part. I guess I couldn't say. There wasn't any resolution of the motion. She appears to have accepted. I guess I can't even say. There's no way to tell from the summary judgment decision what her view of those issues was.
She doesn't address it one way or the other.
So we don't know if she relied on exhaustion.
We don't.
We don't.
But I take it your point is that if at least, and that with respect to the medallions, that at least if we are applying the desolate standard, that you may be looking at what proffer was made and how and when by the department differently?
I'm sorry, I didn't hear your honest question.
If you, leaving aside the food and the prayer rug and the oil, which, as I indicated, I think have substantial problems even under Turner. The medallion, as Justice Cordy said, that's in a different ballgame, but you're suggesting that if we apply for Massachusetts law purposes the desolates standard, which applies to the religious provision of our, separate religious provision of our Constitution, that we would then view the trial judge's disposition or consideration of your motion to strike the affidavits differently than we would in any other circumstances?
That's right, Your Honor. There would have to be shown by the departments a compelling state interest, and they would have to demonstrate also that there was that the restriction was narrowly tailored to achieve that interest. And I don't think there's been any showing made of the narrow tailoring or consideration of all. The only evidence of consideration of alternatives is that Mr. Ahmad gave them alternatives of approved vendors, which were rejected.
Well, if we apply the desolate standard.
Did they reject the vendor? Did they say, we're just not going to explore, we're going to find our own vendor? Or did they say, we've taken a look at this vendor and the vendor is fine for watches, but the vendor's doing something with its medallion production that doesn't meet our needs?
I don't know what the rationale was for rejecting Mr. Ahmad's suggestion on the vendor.
In part, there's no administrative record because it doesn't appear that there was a sort of an administrative appeal within the system. Maybe there would have been a record then. I don't know. But getting to the desolate standard here, which is the strict scrutiny standard, let's call it that, if we were to apply the strict scrutiny standard under the Massachusetts Constitution, we still, that only leads us to whether or not there was a violation of the Constitution. That doesn't translate necessarily into a claim for damages unless that was perpetrated inconsistent with the Mass Civil Rights Act.
That's right. That's correct. For a claim under the Mass Civil Rights Act, there has to be a showing of threats, intimidation, or coercion. I think that
That the constitutional violation was, in essence, perpetrated through threats, intimidation, or coercion.
That's correct. And on coercion, Your Honor, I believe that there is, relatively recent case law, especially this Court's decision in Buster, indicating that moral coercion is one of the applicable standards. And in the prison setting where an inmate is forced to either stop practicing his religion the way he is mandated by his faith, or to abide by the department's regulations, that states a claim for moral coercion under the...
Well, it certainly, at least according to the federal district court, it certainly would even satisfy, I'm looking at the opinion in the,
Gordon v. Pepe?
Yeah. Plaintiff is behind bars and depends on the Commonwealth to provide him with nutritionally balanced meals. The choice defendants would force him to make between a healthy diet and his religious beliefs satisfies any definition of coercion.
That's right, Your Honor, and I think the diet issue is particularly poignant. You have a situation where an inmate is forced to either eat a diet that's repugnant to his religion to stay healthy and stay alive and abide by the department's restriction, or to...
Go hungry.
And that's not a tenable choice, and that's coercion, I think, as the Gordon point is made by any standard. Are there additional questions of the Court?
The red light is on and your time is up.
Thank you.
Thank you, Mr. McGalligan. Mr. McFarland.
Please the Court, Richard McFarland for the defendants, Department of Correction, Michael Maloney, Ed Fico, and John Marshall. I'd like to address just briefly the issue of the PLRA raised earlier. In that case, it's clear...
I'm sorry, which one?
The Prison Litigation Reform Act, the issue of exhaustion of remedies. And it's clear in this case that it's undisputed that Mr. Ahmad did not...
Could you just say the acronym slowly for me?
Sure. The Prison Litigation...
No. What are you referring to as...
The PLRA.
How do you say it?
Prison Litigation...
No. PLRA.
PLRA.
Okay.
Well, you're going to say it's clear because of the affidavits that were undisputed?
Correct, that he did not file, he does not admit that he filed any administrative remedy requests, and instead of, he did file one for the halal diets. That's undisputed, that was in his complaint.
But he had a motion to strike those affidavits, which the judge never ruled on.
That's correct, but clearly that motion was without foundation. He alleges that it was a surprise. Well, the issues of...
But it wasn't determined.
Correct, it was not decided by the judge.
Before a judge rules on summary judgment, they've got to deal with these kinds of motions and stuff so that there's a clear record for us to review and for him or her to act upon. And so you've got this nebulous thing floating out there that was never acted on. It seems to me to make your position very vulnerable. I don't know if he presses it in his brief.
Well, the record did contain numerous information that discussed the administrative remedies available to Mr. Ahmad, and the fact that he was well aware of deposing various DOC officials who discussed the remedies and the need to comply with these procedures in order to maintain his claims. But
well, whose burden is it to show? Is it his to show that he did, or is it yours to show that he didn't?
It's the Department's burden to raise his affirmative defense, which we did, and we presented affidavits in support of our defense that showed that there had been no remedies filed by, or a request filed by Mr. Ahmad for these three issues, the prayer oil, the medallions, and the prayer rug.
And how long before the summary judgment was acted upon did you file these affidavits?
Oh, I would say several weeks, if not more. Our defense was also raised in our answer to the complaint. So certainly Ahmad had full notice that this issue was being raised as a defense, and this PLRA defense has been in existence since 1996.
Well, that's no good either unless there is something to back it up on summary judgment. So these affidavits, again, come back into the picture in the motion to strike.
Had discovery closed?
Discovery had closed.
I thought that was the sort of fundamental point. Discovery had closed.
But the individual that did one of the affidavits replaced Andrea Modi, the Director of Program Services, who had left. So, and he had deposed Andrea Modi, who had discussed at length these issues and the whole process for raising administrative reviews and exhausting those reviews.
I won't go on forever, but in her deposition, did you get into this? Did he file the right papers and that kind of thing?
I'm not following.
In the plaintiff's deposition.
Did she testify that there had been no, did she testify that?
There had been no administrative appeal?
No, she did not. She just raised with him the examples of what was required in the process that had to be done in order to comply with the Religious Services Review Committee.
And I take it that she was represented by counsel?
Correct, she was.
And her counsel could have just asked a question at the deposition saying, and were these procedures followed? Correct.
Who are we talking about?
A woman named Andrea Modi, who's in the record, who was the former Director of Program Services for the Department of Correction.
Okay, so we're talking about a Department of Corrections witness.
Employee.
Yes, what I'm saying is if she's at a deposition testifying, this is what you have to do, 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 her attorney, the department's attorney, can say, did this inmate do that? I mean, you're entitled to ask questions at a deposition, correct?
Correct.
I think it's fair to say, at least from my viewpoint, that if this decision, summary judgment decision, rests at all on exhaustion of administrative remedies, then it's very vulnerable.
Well, Your Honor,
now, it may go out on some other basis, but...
Can I ask that question, though? I mean, it seems to me if you look at the PLRA, it says no action shall be brought until such administrative remedies as available are exhausted. It seems to me to be a predicate. Once you've raised it as affirmative defense, it seems to me, just reading the statute, that it really is the plaintiff's burden to say, no, we've met that hurdle, therefore we qualify.
But it's an affirmative defense.
it would shift, yes.
But it's an affirmative defense.
Well, even if it's,
We're required to raise it.
But you're required to establish, and that's what I'm saying. It would have been, if you've got the department official there who presumably is testifying because somewhere in discovery she's been identified by the department as the person most knowledgeable about the facts in this case, correct?
Correct.
You simply say, ask her, boom, 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 were these followed? No. I mean, you could have filed a motion for summary judgment the next day.
Well, anyway,
all right.
Is there any other basis?
Well, we think...
We've sort of beaten this exhaustion
Yes,
to death,
well, Your Honor,
where
we
you
feel...
say you've got a clear avenue to winning?
I believe, Your Honor, the doctrine of qualified immunity would render that the defendants are immune from the issues of damages, claims of damages raised by Mr. Ahmad.
including the department? Or no?
The department would not be liable for damages itself.
So
you've
would
got
not
to
be
do it
liable for
personally.
damages?
Correct.
No, but you've got to do it personally, right?
Yes. So defendants Fico, Marshall, and Maloney would be liable in 1983. And our position is that the law was not clearly established at that time with regard to the issues raised by Mr. Ahmad in this
The
case.
qualified immunity would apply to all of the damage actions here?
Correct, Your Honor.
All right. And
Provided there were no factual disputes, right?
Well,
I mean, that is to say, you have to go to what you have to show for qualified immunity, correct?
we have to
yeah,
show
you have
that
to
there-
establish qualified immunity. You have to establish the factual and legal predicates for qualified immunity.
And are you saying there are no factual disputes? This is summary judgment. You're saying there are no factual disputes with respect to the issues of qualified immunity?
Well, I think the courts have said in Saucier is one case, Saucier v. Katz, that you don't need to, that we should have qualified immunity judged or decided as soon as possible. And also that.
No, I
But you didn't do that, though. You didn't file a motion to dismiss based on qualified immunity.
Yes, you did.
Yes, I did.
Filed it twice, right?
Correct. And the judge, both times, different judges said, we need to wait for more discovery to get more facts. It's too premature. So,
May I ask a question on a different subject? I'm a little puzzled. How is it that you were able to provide kosher diets but not the diet for Mr. Ahmad?
well, the difference is that it's based on religious dietary requirements. The Jewish diet, kosher diet requires that it be kept separate from all other non-kosher foods. Also, you need to separate meat from fish. You cannot use the same equipment, utensils, plates, whatever, for both for kosher and non-kosher food. So the kitchens were not equipped. We could not create 17 new kitchens that would create just kosher food for a small number of Jewish inmates. So the decision was made to bring in frozen TV dinners that were kosher and give them to the Jewish inmates. Now,
Couldn't you have done that for those people who were like the defendant?
well, the problem was that the vegetarian diet, which is available to the defendant as of December of 2000, was not a kosher diet. That diet was a vegetarian diet that was used to meet the needs of a number of groups: Rastafarians, Buddhists, Seventh-day Adventists, Hindus, and the Muslims. If that diet had been kosher, perhaps it could have been applied to the Jewish groups as well, but it wasn't. So the Jewish inmates could not partake of the vegetarian alternative diet. But since the Muslim inmates did not have the same requirements of having separate kitchens, separate utensils, and everything else, they could, legally in the religion, partake of the vegetarian diet.
Well,
Wasn't there a
disputed
caterer or a
issue-
food? I'm sorry.
Isn't there a disputed issue of fact as to whether or not this, I mean, you've got the period before 2000. This is a sincerely held religious belief. You make a determination of fact that the vegetarian diets that were being supplied by the Department of Corrections.
Before 2000, there were no vegetarians. We're talking pork-free meals before 2000.
I'm talking about post-2000, whether the vegetarian diets did or didn't comply with halal. If they did, end of case. If they didn't, problem. Correct? In other words, you know,
But for
it's a
purposes
functional
of
equivalent to
qualified
saying...
immunity, how can the DOC officials be held to the standard that's necessary to defeat qualified immunity, if it's so unclear?
Well, why
I
is it
think,
unclear?
correct, the law was very unclear, and there are numerous cases in the 90s that said that if you provide a Muslim inmate with a pork-free diet, you've met the needs. And I've quoted in my brief, 5 or 10 cases that cite to that they say generally a Muslim inmate is satisfied with a pork-free diet.
But wasn't the diet here not pork-free? Weren't there pork byproducts even in the vegetarian meal?
No, well, there's a question about Jell-O being. We know for sure that the Jell-O, according to the record, was pork-free. Mm-hmm. But the question is, does the Jell-O have meat in it? So that was used for the vegetarian diet. But the pork-free diet was certified, that's in the record, as being pork-free. The vendor is certified as being pork-free.
Well, I assume again, I mean, yes, I think the case law is very clear that you try to decide qualified immunity as soon as possible. It seems to me that the department has a real problem for the period 1995 to 2000. Then with respect to 2000, the inquiry, again, is, did the particular individual's conduct violate clearly established statutory or constitutional rights? If the clearly established right on which the non-violation that the department asserts is pork-free is sufficient, and there are numerous cases, that's fine. But if there's a dispute as to whether the diet is pork-free, which is what I assume, in other words...
That's not in dispute, is it?
Well, no.
That's not in dispute.
Agreed. I heard the defense attorney say that he got a pork-free diet up until 2000.
Correct.
And you're saying that there are cases that say that, at least back then, up till 2000, that pork-free met halal. So therefore, how can DOC have violated a clearly established principle?
Yes, it was not reasonable, or clearly established to any reasonable official that by giving a Muslim individual inmate, a pork-free diet, you were violating the law. It was not clearly established by any means. And
then from your argument, I guess, proceeds in 2000, 2002, he was given pork-free and meat-free, but there seems to be a question whether the gelatin is actually meat-free. But again, how can it be a clearly established violation of a constitutional principle when it isn't even clear today whether the gelatin contains meat?
Correct. And there are a number of cases, even a Superior Court case of a couple of years ago, which the Superior Court addressed our program regarding vegetarian alternative diets and found that it was lawful and there was no violation of the the Constitution by providing this inmate, in that case, with a vegetarian alternative diet.
Can I ask you this? Have the policies with respect to prayer oil, prayer rugs, for example, we assume medallions are now back available through
Correct.
prison facilities, but policies with respect to prayer oil and prayer rugs, have they changed? Are they the same? What's the current practice as a result of this?
They
lawsuit?
are the same, Your Honor. We still provide the inmates with prayer towels that they can use. We always have provided prayer rugs in the Muslim temples, the masjids. So each prison will have quite a few wool rugs, prayer rugs in the temple for use by the inmates. But in the cells, we allow them to have the prayer towels.
Are they the same size as the prayer rugs?
In the record that they are, a number of testimony from Mr. Rabin that they are sometimes as commercial prayer towels.
But they're not the same size as the prayer rugs in the places of worship.
Well, it varies. Some of them are huge rugs, and some of them are small individual rugs. But the individual rugs are thicker, they're a bulkier rug than the prayer towel. That is what led to the security concerns and the decision to allow the prayer rugs to be in the masjid, but have the prayer towels available to the inmates for use in their cells.
And these are sold as prayer towels?
Well, they're given away to the inmates as prayer towels.
No, I don't mean sold. They are acquired by the Department of Correction. These are items that are manufactured for use.
Well, the prayer towels themselves are normal, everyday towels.
Okay.
That are designated as prayer towels and kept separate from the other towels.
Sure. Okay.
And therefore, the inmates can wash them in their cells if they need to. Providing the prayer towels enables us to deal with a whole host of security concerns. The concerns that the prayer rugs would be in the cells would be used to hide contraband. There's potentially a fire hazard with a prayer rug in the cell. Are there any more questions?
Thank you, Mr. McFarland.
Thank you very much.